as I call 124892 Karbank Holdings LLC versus Regional of Evangelical Alliance of Churches and Diversified Acquisitions LLC. Mr. Dugan?
May it please the court, John Duggan on behalf of Diversified Acquisitions LLC. As the Court of Appeals decision makes clear, this case presents the question of what legal duties, if any, does a purchase money mortgage holder have to an inferior property interest that is recorded 3 years after the mortgage is recorded. The Kansas recording statutes provide no duties for that superior mortgage interest in notifying or in any way alerting that inferior interest of a loan modification. In this case, no one disputes that if Bank of Prairie Village, who sold the paper to Diversified, had entered into the exact same loan modification agreement that Diversified entered into, that Karbank would have no rights, no complaints, no duty breaches. The Bank of Prairie Village loan documents set aside over here were entered into 3 years before the Karbank right of first refusal. There are no contractual privity between those two sets of documents. 3 years later, Karbank, with the advice of their counsel, Neil Karbank, knowingly took a property interest, a right of first refusal, in property that they knew was subordinate to the mortgage. Mr. Karbank, on behalf of his client, family-owned business, reviewed this mortgage and these loan papers, and in fact knew that the entering into this document and the recording of that interest in the property breached the mortgage, and readily admitted that when they took this interest in the property and the right of first refusal 3 years later, it was subordinate to all the mortgage rights. And no one here disputes that had Bank of Prairie Village entered into the exact same agreement that Diversified entered into on December 30, 2015, there would be no dispute, no argument, no breach duty, no claim.
So when we look at if we take Diversified out of the deal, which is what I think you're talking about, we look at this through the perspective of the bank. The bank, there was nothing keeping the bank from doing any of the transactions that Diversified eventually did. The right of first refusal, the deed in lieu of foreclosure. They could have modified, the bank could have modified the loan terms, could have agreed to a deed in lieu of foreclosure if that were to occur, without triggering the right of first refusal.
That's correct, and no one's disputed that. And no one also, Justice Biles, has disputed the fact that when my client bought the loan papers on December 28, 2015, 2 days before they entered into the loan modification agreement, that everyone agrees that the simple fact of purchasing the loan papers on December 28, 2015 did nothing, breached no duties, created no obligations to the inferior right. It was the 2 day later loan modification agreement that everyone has claimed gave rise to some legal duty to go to Karbank and somehow either offer them to sell the property or the note, or to alert them that Reach was entering into a loan modification with its lender. And the reality is there is no statutory duty, as I mentioned. There is no contractual duty between these two independent sets of documents that were entered into 3 years apart from one another. Karbank owed no duty to the lender owed no duty to Karbank. But somehow, some way, the Court of Appeals and the District Court found a duty arose for this lender under the common law to go notify Karbank, or to have Reach go notify Karbank in some fashion that they wanted to enter into a loan modification agreement. And the duty that got created using tortious interference as the framework, the duty that got created arose without any contract or statute. And so what we're looking at here is, how did the Court of Appeals, in the context of this case, come to the conclusion there was a duty? Well, the first thing they said was that Dave Christie, on Diversified's behalf, knew about this separate set of documents because he was involved in the church. And as the dissent aptly points out, the whole world knew about this existence because on November 4, 2015, Karbank filed with the recorder's office a notice of its rights in the property under the right of first refusal. Again, had Prairie Village entered into the Bank of Prairie Village entered into the exact same agreement, they would have been on notice of the subordinate 3-year later interest by Karbank. The fact that somebody, Dave Christie, and the rest of the world knew about it is not relevant.
Can I ask you a question about the deed in lieu? I understand the argument. You're arguing that you had that authority contractually when you stepped into the shoes of the bank. What gave Diversified authority to include non-merger language when that deed was recorded?
It was contractually agreed to because
Correct.
the deed that was the deed in lieu was attached as an exhibit to the loan modification agreement. And the form of that document said non-merger.
Okay. Well, at the point that that deed in lieu was recorded, was there a balance owed on the note that exceeded the value of the property?
Yes, or no, there wasn't. The balance of the note, everybody concurs, was less than the value of the property.
Okay. So then isn't Diversified then getting a windfall by including that non-merger language in the deed?
Not any different than anybody else, because the only reason the non-merger language is in the deed is to protect the lender that if they have to clear up the title by foreclosing, it goes to foreclosure sale. And in fact, a public bidding occurs just as if Diversified had foreclosed back in December of 2015. And any public bid that exceeds the value of the loan is going to the borrower as part of their proceeds.
So at the foreclosure, you just would not have had the right to collect any bid exceeding the note balance.
No, Kansas law is crystal clear. Whenever you
Okay.
foreclose as a lender, your maximum amount is what you're owed on the loan. The Court of Appeals, back to this argument about how they found a duty here, said, well, wait a minute. Dave Christie and the rest of the world knew about it, but Dave Christie was involved in the discussions that gave rise to the right of first refusal. And again, that's a red herring in this sense. Dave Christie, 6 months before they bought the paper, was engaged in the discussions about the right of first refusal. Karbank was the only one represented by a lawyer in that whole transaction. The church was not. Karbank's lawyer reviewed all of the title work, the mortgage, and knew they were subordinate to it. And in those discussions, when Dave Christie was a trustee of the church, nobody ever suggested that he misrepresented any facts to Karbank about their priority, about whether or not they would jump ahead of the mortgage. They've never complained in this case that Dave Christie, in fact, said anything that was inaccurate when the right of first refusal is being discussed. So again, the fact that you were involved in discussions and knew about something the rest of the world knew about can't give rise to this legal duty. They said Dave Christie had a conflict of interest as part of the context. Dave Christie and Reach were always adverse to Karbank. When Dave Christie and Reach negotiated this separate set of documents over here, they weren't in any fiduciary duty to Karbank. Karbank had its own lawyer. When Dave Christie bought these loan documents for Diversified, he didn't have any duties to Karbank. He was adverse to them. He wanted to protect his priority. There was never, ever a conflict of interest with Karbank. If there was a conflict of interest, it was between Reach and Diversified, which would be Reach's legal rights to assert, not Karbank's. Next, they said that there was a no arm's length transaction because the Reach and Diversified were attached at the hip. But as I mentioned earlier, everybody agrees that if Bank of Prairie Village entered into the exact same agreement, giving them 7 months to sell the property, and if not, take a deed in lieu, that agreement was enforceable. How can an agreement that would be enforceable for Bank of Prairie Village not be enforceable for Diversified simply because Dave Christie was on the board of trustees? It does not rise to the level of this duty that they created. The last thing, which I think is probably the biggest misstep, is to suggest that taking the deed in lieu somehow eliminated Karbank's rights. Nothing could be further from the truth. Karbank recorded its interest in the recorder's office, and had Bank of Prairie Village entered into the exact same agreements in this case, it could not sell that property after it took the deed in lieu without dealing with Karbank, because they clouded the title by recording the notice of their right to buy the property. Bank of Prairie Village would have to go to Karbank and get them to voluntarily release it, offer them the contracts to satisfy the agreement, or foreclose them out. That's the exact same position they were in with Diversified. Receiving a deed in lieu did not clear up the cloud on title. And in fact, as the dissent points out, Diversified went to Karbank with 3 separate offers between the time of the loan modification and the time the lawsuit was filed, saying, here's 3 offers, do you want to match them? Without foreclosing. And had Karbank never responded, Diversified would have been left only with its ability to file a foreclosure action to wipe out the cloud on title. But this case actually does something more than just find this duty. What has happened as a result of the facts of this case is that purchase money mortgage holders now have a quasi fiduciary duty to inferior property rights, because the Court of Appeals language has suggested that the purchase money mortgage holder has some duty to go communicate with an inferior property right, even though there's no statutory duty, there's no contract duty, it's now a common law duty. And more importantly, they've been adverse. Diversified and Christie were always adverse to Karbank. The purchase money mortgage holder, if it's Bank of Prairie Village, is adverse to Karbank. Instead of being adverse to them now and being able to protect themselves from title clouds that were illegally filed in breach of the agreements, that lender has to go protect the inferior property interest. This court has been loath to create fiduciary duties for lenders, even with their borrowers. It's a contract duty. But now we've backdoored our way into a quasi fiduciary duty that lenders are going to owe to inferior property interests that are recorded against their collateral. Thank you for your time.
May it please the court. I'm here on behalf of Reach, and we have a limited amount of issues affecting Reach. The biggest of one, I want to start with a quote from the dissent. This case presents a very simple issue made to appear complicated by the irrelevant noise going around it. There was no breach of contract. Put simply, as Mr. Duggan explained several times, if Bank of Prairie Village had done the same thing, there would be no breach. Karbank would still have its right of first refusal. Nothing changed as a result of the deed in lieu of foreclosure.
The title of the property transferred, right?
The
And
title to the
that transfer was supported by consideration between 2 parties. Would you agree?
I would not agree that it's a sale. And I don't know that we even need to get to whether or not it's a sale. We do know that Diversified had a prior interest. They have a superior interest in this property. Everybody agrees to that. Karbank was subject to that interest. Karbank's duties between Karbank and Reach were subordinate to Reach's duties to Diversified due to the priority of the loans. So regardless of whether the title changed, regardless of whether consideration occurred, nothing happened to the right of first refusal.
But isn't that a sale? I mean, that is the definition of a sale, right? I mean, title changed for consideration. Why wouldn't that trigger the right of first refusal? At least give Karbank the opportunity to, make an offer that might be better than the deed in lieu, right?
It is, well,
Or match whatever that consideration was.
if a deed in lieu is considered a sale, which many jurisdictions feel that it is not, no bank will ever use a deed in lieu. They will be forced into mortgage foreclosures every single time. Deed in lieu is the same as a mortgage foreclosure. There is no choice but to sell it to one party. If this is a sale, they have no choice but to sell it to one party, and that's the lender. The lender has this heavy hand in the transaction. They have all the control. It is not a mutual discourse. It is not an arm's length transaction. It is a remedy for the lender. There's no freedom to contract here. So it cannot be considered a sale. A deed in lieu is a remedy that we encourage. Courts encourage because it avoids litigation, it avoids clogging up the courts, and it keeps parties in control of what their outcome is. Here, the church wanted to avoid a foreclosure, partly because of the stigma of a foreclosure and on the church. And the dissent talks a little bit about this and cites to articles of people smarter than me about how that affects a church. So,
Excuse me, regardless of whether or not there was a sale, was there a contract trigger by virtue of the language of the contract between Reach and Karbank?
no. Had Reach reached a sale, I was trying to avoid the double. If Reach had made a sale of the property during that 7-month period, the extension of time from the loan modification agreement, yes, that language would have triggered the duty to notify Karbank. And that was contained within the loan modification agreement.
But I think the language in the contract was a little bit different. Didn't it have two requirements that had to be met in order to trigger the right of first refusal with Karbank?
And I don't recall that right off the top of my head, but it had the same requirements that Karbank had in its right of first refusal, the exact same. And again, this did not trigger that. This was not a sale. Whether or not it's a sale is not even it's not even an issue, because Karbank and Reach had a subordinate interest. The deed in lieu did not change. The fact that the deed in lieu was signed did not change Karbank's interest whatsoever. Karbank obtained its right of first refusal knowing that it was subordinate, knowing that the Bank of Prairie Village could at any time foreclose and cut off its interest entirely. I'm sorry, I'm out of time, and
I have a couple questions, even though.
Absolutely.
That's okay. I want to take a big step back and just try to clarify in my mind this, what I'll call the equities of this case, or the practical realities, which may or may not matter with respect to the legal issues, but we have a property that's worth $2 million. At least that's in the record.
yes,
We have a loan that I'll just shorthand to roughly $900,000, right? Is it true that in this case, what's happening is Karbank and Diversified are essentially fighting over the $1.1 million of equity? I mean, one part or the other is going to walk away with that 1.1 million in equity. Is that accurate? I mean, I know I'm just
assuming that the property sells for that.
right. Just
The equity does go to the title holder.
right. So
So,
my summary, while not framed in legalese, is roughly accurate.
roughly accurate, yes.
So that being the case, it seems there's a windfall here potentially. And I'm just curious from the church's perspective, how is it that the church seems to be the big loser here, I guess is what I'm driving at. How is that?
I would agree with that.
And isn't that a problem? And if it is a problem, how does that problem impact the legal questions?
It is, I would agree that Reach is the big loser in this case. I don't think it's a legal issue because in a foreclosure, for example, and as you all know, that if somebody outbids the lender, the excess proceeds go to the owner.
Right. That makes the church the big loser here.
It does.
So why are you here arguing on behalf of Diversified?
We're not arguing on behalf of Diversified. We're arguing on behalf of the church.
Well, you're arguing on behalf of affirming the Court of Appeals decision.
Absolutely.
But why?
Because there was no breach of contract. Reach paid the entire judgment. Not only did it lose its equity, it paid the entire judgment from a foreclosure. So what we have is the inability of Reach to reimburse its lenders, its parishioners. And what they had was the inability to pay the mortgage. The lender had the ability to foreclose.
Well, what did Reach get out of this deal? You seem to agree with me. And again, I'm putting this in very, I'll call it street terms. Reach got the raw end of this bargain. And it just seems like I'm a little surprised that you don't seem concerned about that.
No, I am concerned about that. And we would have obtained some of that equity back if the offers to purchase had been made.
And I'll just last follow up. That whole line of questioning strikes me as at the heart of this arguable self-dealing that went on. Could you just address that briefly? I mean, was there self-dealing from the church's perspective?
I don't think so.
You had a trustee of the church and an owner of Diversified agreeing with himself.
We did.
Okay.
We also had the trustee of the church promising, whether hollow or not, promising to reimburse the church's parishioners. And that is in the record that the parishioners still believe that if Diversified is able to get the proceeds from the sale and their excess proceeds, those proceeds will go to repay the church.
So that's another way of saying you think you've got a piece of the action here. You've got a piece of this windfall.
And I wouldn't call it necessarily a windfall. It's how the law works. And we can't decide, for 150 years, since 1874, Kansas has decided priority interests first in time, first in right. If we change, and that's always been decided as an objective basis, you look at the documents that are on file with the county, you decide what those documents say and what they mean, and that's how you decide priority. The Court of Appeals put an entire section on the motives of Diversified. And if we want to get into motives, then we're inserting within the recording statutes an amorphous and opaque relationship that may or may not exist, that may or may not affect priority. And we can't do that. We haven't done it for 150 years.
Now, if you would have forced the foreclosure and not enter the deed in lieu, the church then would have stood in the position to get that 1.1 million. Is that correct?
If it had been foreclosed, yes.
And,
Yes.
okay.
Thank you.
All right. Mr. Manson?
Madam Chief Justice, my name is Brad Manson. Again, I'm here on behalf of Karbank Holdings LLC. We view the case procedurally at this point as over. Plaintiff's unconditional satisfaction and release of judgments is a complete discharge of the debt created by the judgments, including the right to challenge the judgment on appeal. All other issues are moot. So the question of whether appellants come here in equity or for some reason to avoid the filing of the satisfaction of judgments has to do with whether they're here with clean hands. Through numerous bad acts and intentional procedural neglect, appellants have no standing to appeal and have acquiesced in the judgments. They never filed a stay at any time. They never even requested that they not have to file a bond. And how many times did they have an opportunity to request a stay? And before how many courts did they have that opportunity? first in the district court before the court was docketed in the Court of Appeals. When Reach appealed to the Court of Appeals, it had an opportunity. When Diversified appealed its substantive judgment to the Court of Appeals, it had an opportunity. Then when Diversified appealed the confirmation hearing, it had an opportunity to request a stay. At no time did any of these defendants request a stay. At no time did they request a waiver of a bond.
I think in terms of, I understand the procedural, the mootness, the standing and the acquiescence stuff. I think probably it's going to be better to spend our time with the other issues.
Okay.
From my perspective. But I do want to ask you on the one that you just, on what you just raised, the counter to that from the Court of Appeals was that your position, if we were to adopt it, would basically require every appellant to have to file a supersedious bond in order to have the right to appeal. And that really the only thing that's going on here is they're taking, if they don't file the bond to stop your execution of your judgment, they're just taking the risk that you're going to chase after them. But if we hold for them, then all of that gets undone.
Well, Justice Biles.
Because you lose your judgments. And then it's got to, and then the district court's going to have to go back and, you know, and settle the dust. And so how are you not asking us to require every appellant to, in a civil judgment type situation, at least to file a supersedious bond, which has not been our practice?
I don't think that the court has to make a blanket rule like you're suggesting. I think that the court can acknowledge that in this case, these defendants, through numerous acts throughout the context of this case, ignored procedural requirements. So what's the
source of law for that? Just some kind of notion of equity that we get to figure out, you know, who was better than the other guy, and so enforce rules on them.
Well,
I don't get where the source of law is for what you're arguing for.
Well, what's the purpose, Your Honor, of the execution statutes then? What's the purpose then of granting judgments and having a plaintiff have judgments and then having an entire chapter in Chapter 60 for execution? It renders it meaningless. The plaintiff has the right to execute on its judgments. The defendant's remedy to stop that execution is to file a request for a stay. And the courts have noted over and over that the court is very liberal about granting a stay. The court is liberal about waiving the requirement of a bond. But here, they just ignored that requirement entirely.
Well, isn't it a matter of risk, really? If they lose and you execute, then their risk is that you will get money from them.
Yes.
And their risk is that, and your risk is that you'll have to pay it back.
Well, their risk at the end of that hypothetical is that we'll file a satisfaction of judgment. And a plaintiff has a right to file a satisfaction of judgment. Plaintiff controls the litigation, may ask for its remedies when the plaintiff is satisfied that its remedies have been met. And in this instance, the plaintiff left money on the table. It didn't collect all of its judgment. And when that occurs, the plaintiff is satisfied. This is something we all learned in law school, that a satisfaction of judgment ends litigation. And the defendants had an opportunity to stop that process. They had an opportunity at every turn. Think about what happened just before the district court was about to enter partial summary judgment on the breach of contract and on the tortious interference. The district court then was about to issue that decision. Plaintiff had filed a supplemental motion for summary judgment to fill in the price. And as we've already discussed, the price was $912,444.84. The defendants concocted a scheme and filed a bankruptcy action that was in bad faith. And they created a limited warranty deed. And I know you have a big record here. This is in Record on Appeal, Volume 25, Exhibit 23. And this is a limited warranty deed that resurrected an extinguished mortgage on the property. So when the deed in lieu of foreclosure was filed and completed, the mortgage that was on the property was extinguished. So what they did was
Why is that? Why was it extinguished?
under 58, 29, here, excuse me. Under 58, 2309A, a mortgage only secures a debt. If there's no debt, there's no mortgage. The security interest only exists to secure a debt. In the deed in lieu of foreclosure, Reach acknowledged that there was no debt and all debt was forgiven. So when the deed in lieu of foreclosure was completed and the deed went to Diversified, Diversified had title to the property and there was no debt. And therefore the mortgage was extinguished.
As a
And
matter of law?
as a matter of law, yes, sir. And so then what they tried to do in this limited warranty deed was resurrect an extinguished mortgage. And if you look down the line at their arguments that they try to make here about that plaintiff has requested its judge or has collected its judgment twice, they use this limited warranty deed that created an already extinguished mortgage to claim then that there's double collection of damages. So they set up their own issue that they're bringing before the court to prevent plaintiff from executing on its judgments.
Do you agree the bank, let's just take Diversified out of this whole transaction. You got a bank with a mortgage. Your right of first refusal gets recorded after the bank's done its filings. And so you clearly are subordinate to the bank and the loan documents and all of that.
Yes.
Are you contending that the bank could not have modified the loan terms and agreed to accept a deed in lieu of foreclosure in the event of foreclosure without triggering your right of first refusal?
I think the bank could have done that, Justice Biles.
Without triggering your right of first refusal?
Yes, it could have. But the bank could not have done that if it acted as Diversified did to negotiate the right of first refusal. So if the bank had been involved, so Diversified then ends
By
up.
definition, the banks, I mean, they're coming in to modify terms. And so they're going to be negotiating with the lender. I mean, that's how money gets loaned in commercial transactions. Typically, there's lawyers on both sides in a big deal. There's going to be negotiation. Somebody's going to say, well, if we'll do all this, but if you go into foreclosure, we're going to, then you have to agree to give us a deed in lieu of foreclosure so we don't have to go to the trouble. I'm trying to figure out if that triggers your right of first refusal when it's the bank doing it.
I think it does.
How?
If the bank had knowledge, it was Reach's obligation to inform the bank of the right of first refusal.
Well, you've got it
Karbank-
on file. I mean, I don't want to.
Well, you have the memorandum on file.
Yeah, I don't care about that. I mean, I think they're on notice the second you've got it filed. I just want to know whether the bank itself, the first lender, is unable to enter into these transactions without triggering your right of first refusal, because the other side says you don't dispute that.
I don't dispute that. But that's not the case. That's not where we are. Diversified negotiated the right of first refusal. It's the same entity that then bought the bank's mortgage. And they bought the bank's mortgage in an effort to begin their scheme to avoid the right of first refusal.
So the pushback to that is, so what? What is the source of law that says that is different than what the bank's doing?
Well,
I don't get that part.
Well, so what is because it's a tortious interference with the contractual rights between Karbank and Reach. That's the so what.
But the bank could have negotiated those same terms and not tortiously interfered with your right of first refusal.
Well, the bank
By
had,
law, as a matter of law.
but the bank had a first priority. When Diversified purchased the mortgage, it purchased it without that first priority, particularly
How?
when it began to negotiate with Reach to do the deed in lieu, which it did immediately after it bought the mortgage. So it bought the mortgage and entered into the deed in lieu transaction, bang, bang, one right after another. It also entered into an exclusive right to sell the property. A different entity of Mr. Christie's also entered into an exclusive right to sell the property. An exclusive right agreement, to your point, that was signed by David Christie on behalf of Reach and on behalf of Diversified.
So can I ask what I think the line of questioning is, but slightly differently? I want to talk about the economics of deeds in lieu of foreclosure.
Okay.
Does that ever make sense when there's a substantial equity in the property economically?
Does what make sense?
A deed in lieu of foreclosure?
I don't think so.
I mean, deeds in lieu of foreclosure, I would think, I'm no economist, makes sense when the value of the property is either roughly equal to or less than the amount owed.
I agree
Is that
with that.
correct?
I agree with
So my follow-up question is there anything in the record and or simply, I guess I'll ask common sense, that would suggest that Reach would have entered into a deed in lieu of foreclosure with, is it Prairie
Bank Prairie Village.
Prairie Village?
Right.
Bank?
No, they wouldn't have.
And is the reason that they wouldn't have because they're giving away $1 million?
Yes, sir.
Okay.
That is correct.
Well, is that a foregone conclusion though? Because there was a 7-month period of time that Reach was allowed to try to sell the property, and they weren't collecting anything during that time. And also the fluctuation, there's some fluctuation at least in values of real estate. So if there is a sheriff's sale, you don't always have bidders that are going to come in and bid
Pay full value. Yeah.
full value or even part value. I mean, sometimes
Right.
the bank wins and sometimes the mortgagor wins or the debtor wins, right?
Justice Wilson, you're absolutely right. I think all of this is correct. The Bank of Prairie Village would not have entered into a deed in lieu transaction. The bank was not looking for a windfall. What the bank would want is the value of its mortgage to be paid back. The reason that Diversified entered into the deed in lieu was because Diversified was trying to take the equity in the property for itself.
What
And
about,
this is proven over and over again by the filings in the bankruptcy court and in the district court. All of the money that would have been there theoretically was to go to Diversified for attorney fees, for parking lot repairs, for other money that Mr. Christie had put into the property. And that's actually written into this limited warranty deed.
Let me ask you a question. So something you said a few minutes ago, that Diversified lost first priority when they purchased the mortgage, right? Did I write that down correctly?
Yes, ma'am.
Okay, so I'm trying to think in my mind, in my non-commercial mind, that I have a mortgage on my house and somebody purchased my mortgage from a different bank. Do they lose first priority?
I think it depends on their motive, Justice Danvers.
Why? Oh, no, I mean, it's law. It's black letter law. Why does motive come into it at all?
If someone's engaging in a scheme and is trying to avoid what they know is out there as a right of first refusal, then yes, I think they owe everyone a notice duty.
Right, but where's that? I mean, what are you basing that on? Just, you're basing it on just generally unclean hands? Because that's certainly not what our statutory provisions provide. I mean, it's pretty, somebody purchases your mortgage, Bank A is with my mortgage, they sell it to Bank B, and there it is. They still have first priority, right?
I'm basing it on the contract, on the right of first refusal. That was there and filed and was required to be complied with. So that's what created the notice requirement.
What about council's statement about the cloud on the title? Is that correct? Would they need to foreclose against Karbank to clear up the cloud?
They would. Yes, ma'am. They would have to clear the right of first refusal as a part of the foreclosure action. The foreclosure action would be subject to the right of first refusal. And whoever would buy the property would have to take that into consideration because they would be buying it.
Well, why would they care about that? If they own the property, put it on the market, get offers for $2 million, they don't care. If
They
you
might
buy
not
it,
care.
if you buy it for 2 million, right?
They
I
might
mean,
not.
economically, they don't care.
And you know, I think.
In other words,
You're-
it's sorry to interrupt, but
No, that's okay.
clearing the title is not a true obstacle to the interests of Diversified.
If Diversified had filed a mortgage foreclosure action, then we wouldn't be here today. They would have a mortgage foreclosure action. There would be a sheriff's sale.
No, I mean, after they receive the deed in lieu, I think the questions arise out of your opposing counsel statement that there would still be a need to clear the title because of the existence of your
Right of first refusal.
right. But economically speaking, I fail to see how that matters. Because
Well-
from Diversified's perspective, if they're going to sell the property, they don't care who buys it.
At a mortgage foreclosure action, why would Diversified care? I agree with that.
Okay.
Because Diversified at that point would get its 912,000.
Well, they get the full market price of the property.
No, Diversified would get paid its secured interest. It would get paid its mortgage.
Okay.
As would the Bank of Prairie Village, it would get paid its mortgage. And whoever then paid over that amount or bid the highest at the sheriff's sale, they would receive the property.
That's if they had foreclosed without the deed in lieu.
I'm sorry.
I can let it go. I think we were
No,
talking past each other a little.
I
Well,
think that's,
I'll just follow up on that. So the deed in lieu, if you're just going to describe it colloquially, is, hey, we're probably going to foreclose on this because you can't pay, but we're going to give you some time to sell it. Right? Is that apt?
I think that was all a fraud, to tell you the truth.
No, I'm just talking about what is
Generally,
a
you
deed
mean.
in lieu? Well, how would you define a deed in lieu?
A deed in lieu is that I don't file a foreclosure action and I take the deed in lieu of filing a foreclosure action.
But
Give it
you're
to
just
me.
hanging on to it. You haven't filed, you haven't recorded it yet, right?
Well, that was a part of what they did. Actually, Reach did make a couple of 3 mortgage payments in that period of time. There was an illusory attempt to sell the property, but there was never any real effort to sell it. There were no bidders. It was never sold. Nobody had ever.
I don't think the
bought it.
record reflects that. There were 2 companies, there were 2 potential bidders.
Not in the period of time that we're talking
The
about.
7
And the
months?
bidders were all related to Diversified.
I know, I'm just talking about, I mean, it seems like and I think this is what they brought up. I mean, your entire case is based on bad motive, right? Not
Well-
necessarily the law, but this bad motive. Correct.
The tortious interference with contract is based on animus, is based on malice, and has been found in 3 courts that there was malice. And David Christie testified under oath that he was going to do everything that he could to prevent Karbank from owning the property. So yes, there was malice, but in the Reach instance, it's just simply a breach of contract. Reach never notified Karbank of the deed in lieu of foreclosure.
That's the part I don't get why.
That was a sale.
Yeah, okay.
Well, it was a sale. So Reach is choosing to sell the property to Diversified under the deed in lieu.
But that goes back to my bank thing, so I'm with Bank A with my mortgage, and then someone comes up to me and says, right of first refusal, and then the mortgage company sells to Bank B, and Bank B, and I don't make my payments, and then Bank B says, look, we're gonna file this deed in lieu of foreclosure, or not file it yet, but I don't understand why I would have to come to you or whoever was giving me my right of first refusal.
Sure.
I don't see how that's a sale.
But that's ignoring who's doing it here. It's Diversified that's doing it here. In your hypothetical,
Diversified
you
is
have a
big.
pure motive seller. You have a pure motive actor. You don't have a pure motive actor here.
Right, but I mean, how does that affect the law? I just,
Well, it has to affect the law. People cannot engage in contracts and attempt to avoid contracts that they were actually involved in negotiating. And then they develop a process and a scheme to get around that contract for their own benefit. That's what happened here. And that's what should not be allowed to happen. That's what the district court found. That's what the bankruptcy court found. That's what the Court of Appeals found. That you can't separate out the motive of Diversified from the deed in lieu of foreclosure transaction. It's a part and parcel of the same.
so
thing.
if the exact same facts were presented, but there was no malice, then we wouldn't be here.
Well, no, Reach would have breached its contract by not giving Karbank notice that it was going to enter into a deed in lieu of foreclosure transaction rather than offering the property to Karbank. If Reach had notified Karbank that it was entering into a deed in lieu of foreclosure with the Bank of Prairie Village or with Diversified, Karbank would have had the right under the right of first refusal to match that and pay $912,444.84.
Okay.
Or Karbank at least
Can I-
had the right to decide.
For
whether to-
property that's worth $2 million.
So,
Nobody knew what it was worth. Nobody knows what it's worth now.
Well-
Now the district court
Everybody knows.
found
Can-
that
can-
it was worth.
can I say, I'm gonna ask this again, try to ask the same question, but in a very different
Yeah,
way. If this property was only worth $800,000,
right.
nothing that happened here would have been illegal, right?
That's true.
Okay, so yes, so that is the nut of the case, is the fact that there's this 1.1 million of equity that calls into question all of the transactions. Is that a correct summary? I mean, leaving aside the bad motives, it's purely the economics of the arrangement that doesn't pass the smell test.
That's what.
That's your
gives-
argument.
That's what gives Karbank its damages.
Because, well, but it's what, more than the damages, it's what gives Karbank its cause of
Cause of
action to
action.
begin with.
That's correct.
Because if the property's only worth 800,000, there's absolutely nothing to argue about. And there's nothing at all wrong with any of the legal contracts or transactions or recordings or sales.
Well,
right?
or Karbank would have the right to buy it for 800,000 or, whatever. So if you have a right of first refusal, then you could pay if you were the
Yeah,
bank.
Karbank was not going to buy this property for $900,000.
Well,
If it was only worth 800, if it's only worth 800, you're not going to pay off a
Oh,
$900,000.
well, that's certainly true, but I mean, suppose if God told us that it was worth 800,000,
I mean,
yeah.
Let me ask,
I mean-
should we presume as a matter of law, when we evaluate the legalities here,
Mhm.
that we're dealing with economically rational actors?
I agree with that.
No, so you
Oh.
think we should assume that as part of our analysis?
Absolutely. Yeah, why would you not?
Well, you just said God maybe told you to buy the property.
No. I said it. No. We're dealing in the case here that the district court, so this is a part of the record, the district court found the property to be worth $2 million. So that's just a fact that we have to deal with. But I don't think we really know what the property is worth. But for purposes of your consideration, that's what it's worth because that's been found to be the fact. So that formed the basis of the damages. But certainly it's true, if I had a right of first refusal to buy a property at $900,000, but the property had burned down and was worth nothing, then I would not buy it. I mean, that's obviously true. Yeah.
What would have happened if Diversified was attempting to foreclose on its mortgage post the deed in lieu, correct? That's the judgment that it was seeking. And
Mhm.
let's say that plays out and they foreclose
Right.
and you're going to exercise your interest, whether they're priority or secondary. But if they're secondary, how are you really harmed? Because if they can only bid their note balance, aren't you in a position to maybe for 50 cents more be in the same position?
Yes, sir. And in fact, that's okay. If Diversified filed a mortgage foreclosure action and there's a sheriff's sale, then I can go, Karbank can go to the sheriff's sale and Diversified bids in its mortgage, which was exactly $912,444.84. That's also found in the record. And Karbank can then bid $1 million or bid $950,000 and buy the property for that. And that would be how that would have played out. And that'd be fine.
Well,
We
except
wouldn't
at the
be here.
sheriff's sale, you could have had other people that are thinking,
Yeah,
evaluating that this property, God told them that this property is worth $2 million.
correct.
And, they might bid $1.5 million.
That's exactly.
But even if that's the case, isn't your interest still the right of first refusal and you're in the same position to exercise that right?
We are, but now we're at the sheriff's sale.
Right,
And so we're a bidder at the sheriff's sale.
right.
And we may.
But you're a
if it
bidder
gets
under the right of
1.5
first,
million,
but
I may
aren't you
stop
a
bidding.
bidder under the right of first refusal anyway?
I am a bidder under the right of first refusal if I'm given notice that you're selling the
Right,
property.
okay.
What the property was sold for here was it was sold to Diversified for $912,444.84. We just never got notice of that, and we never had the right to match that. And we
It's the
certainly
timing.
would have if we had been given that right.
Right. I understand. It's the timing of that in part.
I think that's right. But no, I agree with all of this. If there had been a mortgage foreclosure action, and in fact, there was a sheriff's sale of the property. In the execution of the judgment, there was a sheriff's sale of the property. The only bidder at that sheriff's sale was Karbank Holdings. Everybody, others showed up. Diversified showed up. Reach didn't show up. Diversified showed up. Diversified didn't bid anything for the property. There were other bidders. It's a commercial transaction. There were other bidders, but no one bid anything except Karbank, which bid in its judgment that it had against Reach. And it acquired the property for that, and that sheriff's sale was confirmed, and we have the property. And the issue now we have, as the proper purchaser of that property with a judgment, the problem we have is that there's still a mortgage on the property. There's a mortgage foreclosure judgment on that property. And that came about because of this limited warranty deed that resurrected an extinguished mortgage. And so that's why we aren't collecting twice here. We're not executing twice because all we're doing is clearing off a defect on the title of property that we legitimately purchased at a sheriff's sale. So that's the right we're trying to enforce here. And in fact, we have enforced it and we filed satisfactions of judgment and no one tried to stop that process at any time. And why isn't that right? Why isn't that okay? It is okay. And so that the defendants through collusion would want to prevent that is the problem here. I agree with this point. I'll tell you who the loser is in this. It's Reach. They were the loser from the beginning. The lawyer that was hired to represent both of the defendants from the get-go was paid by David Christie, who owned Diversified. He'd done this before. He did it in a case called The Bluffs.
Is this, I think we may be getting
It cut off.
far astray from this case. It sounds like.
Well, I'm just saying that this was something that they'd done before.
Okay.
And with this lawyer,
You are out of time if you.
I'm way out of time, no doubt about
If you
that.
do want to conclude.
Thank you for your indulgence. Thank
Chief,
you
I'm
very
sorry.
much for your.
I've got one more, and this is a
Justice
much more
Byers.
benign question. But you made a reference that it's not reconciling with my memory of all the details here. You
Okay,
said that the two offers, the $2.1 million offers that
Mhm.
had gone for the property
right,
were both by insiders.
yes,
Now, I understand that, Matthew Pennington, who's a minority owner in Diversified, did one of those. And
Penn
he's BK Properties, right?
BK Properties is a developer in Kansas City,
So
a
is that
friend of Mr. Christie.
Okay, so that's a friend. And then Pennington is the Penn Dev,
That's correct.
which was from the other one okay.
That's right.
I just wanted to know what the insider aspects were, because I didn't have the one associated with anything.
Actually, it even begins before that, but I am out of time. But in the record, you'll see that there are letters from Diversified, letters from another entity, starting in March, then in April, even before the deed was filed, even before there was a complete default. And Karbank Holdings had no idea who these entities were, and they started talking about, well, we can sell the property for 2 million, or we can sell it for 2. We'll offer it to you for this, and none of those complied with the right of first refusal.
Are there any other questions?
Thank you for your questions and your time.
Mr. Duggan? You reserve 4 minutes.
Thank you, Madam Justice. May it please the court, just 2 points. Justice Standridge and Justice Biles, the offers that came in during the 7-month period were 3. It was a $1.5 million offer that was communicated via phone call to Karbank. There was a $1.9 million offer by
Who was that
Penn.
from? The 1 I have 2.1 twice.
It's never been identified who the $1.5 million
I'm sorry, okay.
offer was from. The 1.9 was Penn Dev. And the $2.1 million was a Kenny Block entity, Block Real Estate Development Services in Kansas City. And yes, everybody who's a real estate developer in Kansas City knows one another, but Ken Block and Christie are not partners. They're not affiliated. The second point is to adjust the economics of the transaction. And just so everyone knows, I think the record's clear. Craig McKelvin was a childhood friend of Dave Christie's. They grew up together. Dave Christie, in the record, I think, had donated over $500,000 to this church over a 2.5 or 3 year time period. And when the Bank of Prairie Village was preparing foreclosure because they were not going to extend the loan terms because the regulators would never have approved it, given the fact that the church wasn't operating and functioning and they had a secured interest, they contacted Dave Christie, this is in the record, to buy the note, which he did. Dave Christie then entered into the transaction, presented these 3 transactions to Karbank to try to get them to buy the property or to waive their rights so he could sell it without a foreclosure to Ken Block, to Penn Dev, or this other party for 1.5. They did not respond. Instead, they sued. So with all the machinations back and forth, there is a foreclosure action pending that we are asking this court to issue a mandate to the district court to allow it to proceed. And we've said in our prayer for relief that all Diversified wants out of this transaction is the $912,000 that the district court says they were owed on the day that they entered into the deed in lieu and transferred the title. And we're in agreement that everything above that should go to reach into the parishioners before we get paid our attorney's fees or interest or anything else, because Craig McKelvin died. He has a widow. And Dave.
How does the equity, what I'll call the equity, the amount above 900,000 get to reach?
You can issue a mandate as an equitable remedy, which we're stipulating to right before you today. Send it back, reverse the judgment.
Is this the first time that's?
No, we offered it to the Court of Appeals and we offered it to the district court in our proposed judgment. And we said, we agree that any proceeds of the sale above our 912 would go to the parishioners and to Craig McKelvin's widow. And those numbers are in the record, and we're happy to provide a proposed order to you in a
Does
mandate.
Reach still exist as
Yes,
a
it
corporate,
does.
like as a corporate entity?
Yes. And so our conclusion is you can direct an equitable remedy from the bench. We stipulate to it over and over. All Diversified wants is the money that they paid to pay off the mortgage. And everything above that would go to them. Now, here's how it works practically speaking. There's a lot of property taxes. They've paid property taxes. And I think whatever party ends up owning this after our foreclosure, if that's the remedy that you allow, they have to pay back Karbank the property taxes they paid, which are about $500,000. And in addition to that, so we think we should get paid the 912. They got to get paid the $500,000 in property taxes. And we agree. You can put it in the mandate and tell the district court, this is the remedy that's been agreed to. Every other dollar that comes out of the sale of that property
If you only
Reach.
wanted the 912, why didn't you just put it up for sale and allow the right of first refusal?
We did. We sent them 3 offers, but not at 912 because at 912 the parishioners get nothing. The
I
church
understand
gets
that, but
nothing. We sent them legitimate offers. We could have done a public foreclosure from day one.
are they legitimate offers if they weren't closed on?
They couldn't be closed on because they all had a condition in the contract that said they got to deal with this title defect. A point earlier, I think, is misguided. The deed in lieu of foreclosure, why would Diversified care? Because it's going to show up on the title work and nobody's going to buy the property and close on a fee interest for $2.1 million without clearing this title defect.
Doesn't the sale itself clear the defect?
No, it does not.
I don't I'm not being argumentative, but
I
help me
understand.
help me
Yeah.
understand why.
The
that's-
only way to clear title to the real estate is to go through a foreclosure, which sanitizes the title and says, everybody that had a lien on that has now been wiped out. You had your day to come and make your case and put your bid in.
That can't be true. Let's say there is no mortgage, but there's a right of first refusal entered into.
Yes.
I mean, and it's filed that,
It's
but
a
you don't
record
have to,
notice.
you don't have to foreclose on yourself to.
No, you don't.
title. You
Reach
just
goes-
you just put it up for sale.
Correct. And then,
But why
if they
is it-
don't, if they don't waive it and it shows up on the title work, Reach is standing there with a title defect.
Doesn't it-
The buyer saying, I'm not going to close
Doesn't it-
on this and have them come
Doesn't
back
it show
after the
up
fact.
on the title work in my hypothetical also?
It does. And I'm saying to you, nobody buys property. No commercial real estate vendor buys property for $2.1 million with a title defect that says, I had a right to buy the property, because the subsequent title defect doesn't go away just because I give you a deed.
Well, that
The title
suggests
company's
that,
going to say, we're not giving you coverage for that.
that suggests you can never sell property with a recorded right of first refusal.
That's correct, unless you complied with it and then they said, we're not going to release it. You'd have to sue to quiet title to get it removed and
Right,
go
but
to.
that's what I'm
court.
suggesting is you can just put it up for sale in a completely transparent way. And then the party that holds the right of first refusal can either execute it or waive it. And
Correct,
that
which is what-
totally clears the title.
It does, but they got to release it. We can't force them to release it. And if they refuse to release it, it's a title defect. And in this case, to your point, there were 3 offers made, said to them, hey, here's 3 offers. Will you respond and say you want it or don't want it? And if you don't want to buy it for PennDev or Kenny Block's number, then we would have demanded that they release that from the records. And if they would not have, then we could have filed a quiet title action to have it removed. But they never responded to the 3 offers. I'm sorry.
Yeah, let me react. I was in one frame of mind until your rebuttal. This idea of this court issuing orders that says who gets what and how and where the equities are and all this just scares me. And because I don't see what the authority is for that, but if we have the authority, which you've just asked us to do, to me, it lends more support to what Karbank wants us to do, which is to kind of take every commercial transaction in the state of Kansas and apply some sort of equity notion to it as to determine whether it's going to go forward or not. That's the way I see the Karbank argument.
I'm in agreement with you 100%. The law ought to be crystal clear for people that have purchase money mortgages. But if everybody here is troubled by this whole notion, I want you to know that we've said over and over again in front of every tribunal that we've appeared in front of, all Diversified wants is the $912,000 and everything else is going to go to the parishioners. Corey Lagerstrom testified at trial. His mom is a school teacher who retired that took her retirement money to put it into the church to buy the property. Corey Lagerstrom sat on the board of trustees with Dave Christie for 3 years. And Corey Lagerstrom said, I trust Dave Christie implicitly. He's always done everything he said. And when he says he's going to get my mom's retirement money back to my mom, I 100% believe what he says. As did Craig McKelvin, who was then alive, testified that when Dave Christie told them he would get the money back for him for his retirement account from the proceeds, he 100% trusted him and believed him. If Diversified is able to foreclose its mortgage and get us $912,000. Dave Christie wants everybody that put money into that property other than him to get their money also. He just wants the $912,000. And if those proceeds are out there to Justice Biles' statement, yeah, that's been in the record. And a person that gives the church over $500,000 over a 3-year time period to fix the plumbing, to do this, to help run the operations, to fund the staff, are they really opportunistically trying to steal the equity in the church when they've told all the trustees this is what they're going to do? And every trustee on the church, without exception, said we 100% believe that this guy will do what he said.
Is there any assurance if that mortgage is foreclosed that there would be bidders in excess of that?
I doubt there will be, and I'll tell you why, because people don't pay millions of dollars in foreclosure sales.
Right.
And if Bank of Prairie Village had foreclosed it, I highly doubt anybody shows up and bids on it because they don't have an environmental. They don't have a bunch of the due diligence that they would normally get. And that's why foreclosure sales typically go for the credit bid of the first mortgage.
If you had gone to foreclosure, the minimum that you would have been entitled to was the $912,000. But what would the maximum be? Is there?
Today,
By the time of the foreclosure sale, would you have been also entitled to claim attorney fees or interest or?
correct, which we asked for.
The increased judgment?
Yeah, we asked for the total of the amount that was due, the 912, the interest and everything else. And at the time of the trial, that number was around $1.45 million. And Dave Christie said unequivocally, if I credit bid the $1.45 million, I'm keeping 912 and the rest of it's going to the parishioners to pay them back. And that number today has only grown, and it's probably north of $1.7 million today with all the interest. And his unequivocal statement is still true. Whatever I get above the 912 is going to my friend's widow, the school teacher, and everybody else that put money into that church. Thank you for your time. I appreciate it.
Thank you. Thank you to both counsel, or all three counsel, I guess, in this matter today for your arguments. The court appreciates those. The court will now take this case under advisement.